The broadcast is now starting. All attendees are in listen-only mode.
All right, well, good afternoon, everyone, and thank you for attending EDGE's webinar today. Today's webinar is entitled Form I-9 and E-Verify, Enforcement Trends, Common Errors, and Avoiding Fines. My name is Meredith, and I will be your moderator. Our presenter today is Nikki Kersey of Cyforth Shaw, LLP. Ms. Kersey is the Managing Director of the Immigration Compliance Center at Cyforth Shaw. Today she will be discussing important topics surrounding the Form I-9 and E-Verify. She'll be covering a wide range of important information that will help you run a successful and compliant I-9 process at your company. Some areas which will be covered are recent ICE enforcements and fines, how to avoid fines, common I-9 errors and misconceptions, E-Verify updates, and more. Before we begin, I just want to point out that we'll be taking all questions at the end of the webinar. To send us your questions, just type them in the questions box in your GoToWebinar dashboard and then press send. And without further ado, I'm just going to go ahead here and make Nikki the presenter, and she will go ahead and get started. Okay, Nikki, you should have the controls there.
Meredith, it's asking me to show my screen. I don't know if that's normal. I don't have the presentation up on my side.
Okay, here. Let's try this. I'll just go ahead and give you the keyboard and mouse controls then.
Okay.
See if that works.
I think so. I think I just made it click forward. Is that me or you?
Yep, looks good. Nope, that's you.
Okay.
You're all set.
Thanks, Meredith, and thanks, everyone, for attending. I'm really excited to have a chance to talk to you today. As you will see quickly, I am an I-9 nerd. I dream about I-9s, whereas you might have nightmares about them. It's my job to dream about them so that you don't have to have nightmares about them. Before we get started, I do have to do this little legal disclaimer. I am an attorney, and so we get to talk about these fun things. This presentation is for educational and informative purposes only. It does not constitute legal advice, and as much as I would like for you to all be my clients, it does not create an attorney-client relationship. This presentation should also not be construed as an endorsement of the products or services offered by Edge Information Management Incorporated or as an endorsement of the legal compliance of any services or products offered by Edge. All right. Without further ado, Meredith did talk about the agenda. I'm going to talk about some enforcement trends, fines and penalties, what it exactly looks like if you're being inspected by ICE, how to avoid fines, and some common I-9 errors and traps for the unwary. I do hope you have lots of questions because I've tried to save time at the end so that we can talk and make this a little bit more interactive. Okay, so despite the heat out there, I mean, it's incredibly hot. Ice, is not melting. Oh gosh, we're flipping through too quickly. Should I go back? Okay. Instead, just like the heat, the enforcement levels are at record levels right now. In the current fiscal year, and this is just through the end of last month, over 2,600 notices of inspection have been issued. That means 2,600 employers in the U.S. have had their I-9s inspected by ICE in less than a one-year period. Nearly 100 managers have been arrested, and that is in connection with criminal enforcement relating to I-9s, which we'll talk about in a moment. Nearly $6 million in fines have been ordered. Again, this is since October 1st. And since fiscal year 2009, the numbers you can see are more than 6,000 employers have been audited. You've got 400 employers being debarred from federal contracting, and more than $75 million in fines ordered. If you compare this to a decade ago, we were talking about less than $100,000 in fines being ordered across the country. So this is an extreme spike in enforcement activity. What I'm seeing in recent ICE investigations is that ICE is no longer hesitant to fine for minor errors. If an error on an I-9 form is considered substantive, And there are various lists out there that you can see in terms of what's substantive, but some examples are an employee not dating the form, or not selecting a status box in Section 1, or some document information being missing in Section 2 when you don't have a copy of the document attached. Those substantive errors, no matter how minor they are, may result in significant fines. ICE has not been as willing in recent years to negotiate and settle for the lower fine levels than in the past. It used to be common for ICE to settle these claims for half or even less than half of the initial fine that was proposed. Now, ICE attorneys often have settlement discretion of 10% or less, and in order to settle for anything lower than 90% of the proposed fine amount, they have to go through several layers of bureaucracy to get approval for that. And whereas in the past we saw ICE focusing on, it felt like sometimes they were picking on the little guys because they would investigate smaller businesses, in part because it takes a lot of time to inspect I-9s. So the lower the number of employees, the easier ICE's job is. They now have a large inspection center that is staffed and ready to go to start doing investigations of huge employers, of some of the brand names that we all have in our households. All right, so what does all this mean? If you have never seen the fine scale for I-9 penalties, I have up on the screen now the civil penalties for I-9 related errors. The ones that I'm going to focus on most today are the first ones, the $110 to $1,100. That's per employee who has an I-9 or who doesn't have an I-9, because you will often be fined for not having an I-9. And those amounts can go up and down. The initial fine amount is going to depend upon the percentage of I-9s that have errors. And that's not the percentage of I-9s you hand over, but the percentage of I-9s that you should have. The percentage of those with errors, the higher the percentage, the higher the initial fine amount is going to be. From there, the fine amount can be adjusted by 25% in either direction based on factors such as the size of the business, the seriousness of the fines, the number of unauthorized workers found, the history of violations. The other items here I did want to show you just so that you have them in your mind and you see how serious this can be. If an employer has a pattern or practice of knowingly hiring or continuing to employ an unauthorized worker, those fines can be as high as $16,000 per worker. Okay, they add up very quickly. All right, and in addition to the civil penalties, criminal penalties can be attached. And these are in addition to, not instead of the civil fines that I just showed you. So an employer can be fined for the paperwork violations and then criminally prosecuted if they're found to have knowingly hired or continued to employ unauthorized workers. Those fines can go up to $3,000 per individual, but the bigger fear is up to 6 months in prison. It can be scary, and these are obviously individuals going to prison, not a company. In addition to the knowing hire or knowing employment violations, you also have to be concerned about harboring. And harboring, I just would warn you that if you're found to have knowingly employed someone who's not authorized to work, and you're providing them with housing or providing them with transportation, there is some risk that that knowing hire violation can turn into a harboring charge. Okay. The other thing to be really aware of here is that the word knowingly is broader than it seems. To knowingly hire someone doesn't just mean you actually had to know that they were not authorized to work, but it also includes constructive knowledge. So if you had reason to know that the person was not authorized to work and you turned the other way and failed to investigate, you could also be charged with a knowing hire violation. One example would be someone who starts work for you and says they're a U.S. citizen, then maybe comes back 6 months later and asks you to sponsor them for work authorization. Someone who is a U.S. citizen should not need work authorization, so it should cause you immediately to investigate the situation and determine whether the person is currently authorized to work in this country. And ICE is not alone. So we focus on ICE, and I'm going to focus on an ICE investigation today, but ICE is not the only government agency that polices things related to the I-9. We're seeing a lot of activity from the Department of Justice's Office of Special Counsel for Unfair Immigration-Related Practices. They have sued employers for document abuse and discrimination during the I-9 and E-Verify process. So these are situations in which employers are asking to see specific documents. It would be, I know, not at my current job, but I have in the past worked at a place in which I was told, now it's time for you to show me your driver's license and social security card. Well, I was just discriminated against. And it doesn't seem like your typical form of discrimination, but that's the type of thing that the Office of Special Counsel is looking out for. Asking to see specific documents is considered, and this is a funny term, but document abuse. And we have seen employers recently sued, and those fines can climb. They're similar. They're $110 to $1,100 for each instance, and they add up quickly. What the Office of Special Counsel often does is they'll ask for a list of employees with their citizenship status, and if they find that you have, for instance, asked lawful permanent residents to provide a green card, they will charge. They will charge in their complaint a count of discrimination for every lawful permanent resident that you have employed. Of course, you may not have done that for every single lawful permanent resident, but it is going to take some work and legal fees to get that list pared down and to reduce the fines. Okay. Other things, asking to see more documentation than is required. This is particularly of concern when you're talking about an employee who might be Hispanic, for instance. So such a person might present to you a driver's license and social security card. If you say, oh, I noticed that you said you're a permanent resident, I also need to see your green card, bam, again, you've just committed document abuse and can face a complaint by the Department of Justice. The third one that I've got up here is failing to handle the tentative non-confirmation process properly. And we haven't seen a lot of action in this area yet, but it seems to be an area in which we're going to start to see discrimination claims. If you use E-Verify, there are very specific rules you have to follow after submitting someone's information to the E-Verify system if the person gets what's called a tentative non-confirmation, which means the government wasn't immediately able to verify their work authorization. In that situation, employers are required to contact the employee and give the employee a chance to contest the tentative non-confirmation. They're given a chance to contact the government and say, look, I am authorized to work, here's my documentation, and ask that the government update the system accordingly. Employers who take adverse action against someone who is in a tentative non-confirmation process may face a complaint by the Office of Special Counsel. And an adverse action doesn't mean you have to terminate the person's employment, but you have to allow them to keep working just as you would any other employee while they're handling that tentative non-confirmation process. Okay. All right. So talked about ICE, talked about the Department of Justice. I've done it again. All right. We just talked about this. The penalties for discrimination or document abuse are listed there on the screen. One real concern that employers have when you're facing ICE and you're facing the Department of Justice is a great deal of tension. On the one hand, your obligation is to confirm that every employee is authorized to work. On the other hand, you can't ask to see specific documents. So I talk to employers every day who face situations in which they're like, you know, look, I want to do a really good job and make sure I'm documenting this person's employment authorization, and I feel like I need more, but I can't request it. So it's important that everyone in your organization that's handling the I-9 process understands the rules, and they do seem to be rules that compete against each other, and know how to walk the fine line between the two. Okay. All right, and then the last item there, which we haven't discussed, is that retaliation is also prohibited. So any employee who files a charge with the Office of Special Counsel or who is otherwise questioning your I-9 or related practices, you cannot retaliate against that person or take adverse action against them, or you could face additional charges. Finally, we have the SEC and states. The SEC, the Securities and Exchange Commission, has been policing publicly traded companies to ensure that I-9 related financial risks are disclosed to investors. So if you are a publicly traded company, you have to be careful about what you know about your I-9s and what you disclose to investors, because errors on those I-9s can present serious financial risks. And so I would advise you or ask you to please talk to your counsel about I-9 issues in order to avoid trouble with the SEC. In addition, those of you who function in states that require E-Verify, you may have started to feel the enforcement coming from the states. I've seen several states refusing to pay their contractors. These are companies that have contracts with the state or with counties. They're refusing to pay until they receive certification that their contractor is using E-Verify. Again, these are states that require use of E-Verify by their state contractors. I've also seen Colorado policing its requirement. Colorado has a certification requirement. It's an extra piece of paper that is kept with the I-9. And Colorado has been auditing employers and requesting those certification forms. All right. Let's go back for a minute to ICE, because, again, that's the agency that we've seen the most action from. And in all honesty, it seems like this is the type of situation in which you have the greatest deal of control and can do the most to prevent fines. If you've never been through an ICE inspection, I did just want to walk you through the process so that you know what exactly happens. The first thing an employer gets is a notice of inspection. Sometimes you'll get a phone call saying, hey, we're going to come tomorrow and issue this. Sometimes ICE agents just show up and we'll talk to your receptionist. The notice of inspection is a relatively simple document. You usually get 2 or 3 pages, and it says, we want to see your I-9s, and then there'll be a list of additional documents and information that ICE wants to see. And it will give you a deadline for providing that. It's usually 3 business days. Sometimes it can be longer. And sometimes you can negotiate additional time to turn over those documents. You have a choice. In most cases, you can either take the documents physically to ICE, or ICE will come back and pick them up. In either event, you're going to have to turn over your original I-9s, and ICE will issue a receipt for them, for the property, saying we received X number of original I-9s. The next thing you'll get will depend upon ICE's findings. Often I see employers get a notice of suspect documents, and this is a notice from ICE that ICE believes certain employees are not currently authorized to work. Once you get that, you're usually given 10 business days to clear up those discrepancies, and that means having a discussion with employees, asking them whether they are currently authorized to work in the U.S., terminating their employment if they are not, and if they say that they are, allowing them an opportunity to present new documentation or to re-present the same documentation to ICE. Then you will talk to ICE about your findings. You'll usually say, we terminated the employment of 7 people. The other 3 claim that their documents are good. In some situations, the employees will be lying, and you have to warn you if your employee is lying and insisting that fake documents are real. I have seen ICE in those situations come back and actually arrest the employees and take them away. And that's something you can absolutely share with your employees and say, look, if you insist that these are real, and they may be, if they are, great. If they're not, just be prepared that we have seen ICE come back and arrest employees when the documents are not real. Okay. If you don't get one of those, the next thing you may get, in either event, if you do get one of those, then the next thing you may get is a notice of technical or procedural failures. And this is a list of technical errors on the I-9 forms. And here you are typically given, again, 10 business days to correct the errors that ICE is informing you of. Then you wait with your breath held to figure out what's going to happen next. You'll get one of 3 different letters. One is a notice of intent to fine, and that's the one you really hope to avoid. The second is a warning letter, which basically says, look, we found these failures when we reviewed your I-9s. Don't do it again. And if you have one of those, it's important to not do it again, because ICE has been known to come back, re-audit, and fine if any of those same errors are being committed after their audit. You may get a congratulatory letter, which is fantastic. It's a nice letter from ICE that says, hey, we audited your I-9s and everything looks great. Keep up the good work. And then they usually invite you to join the image program. If you get a notice of intent to fine, though, it's not necessarily the end of the world. It's not fun. You're likely going to have to pay some sort of fine. And you get a chance usually to negotiate with ICE over that, and sometimes you can settle for a lower amount. You can simply accept the fine amount and pay it, or you can opt to litigate. And we have seen the OCAHO, which is an administrative law judges, we have seen them make significant reductions to fine amounts in appropriate circumstances. I have seen in one case the ALJ actually increased the fine. It was a low amount, it was less than $1,000, but generally you don't see the fines go up. They almost always go down. The problem is most cases don't get to litigation because it is so expensive to litigate them that a cost-benefit analysis will often leave the employer feeling like they have to settle with ICE, which is a frustrating position to be in. All right, so how can we avoid fines? It's difficult to avoid being inspected at all. Usually an ICE inspection comes up because there's been a tip or a complaint to ICE about your business. Sometimes it's an industry focus. So I've seen ICE do quite a few audits of construction companies. And occasionally we've seen what appears to be a random audit, but those are relatively rare. You can't avoid the notice of inspection, but you can often avoid fines by being prepared for the inspection, and I'll tell you how to be prepared, and by doing a voluntary audit of your I-9s ahead of time and fixing any errors you find. It's important that you do this before an ICE inspection. You can still do some of it after an ICE inspection, but ICE really gives you a lot more credit for doing it before they have come to police your I-9 practices. All right, so how can you be prepared? I always try to get my clients to put together a comprehensive compliance policy, and this is an immigration compliance policy. This is a series of policies and language that goes into the employee handbook. One policy would cover immigration sponsorship to the extent that you sponsor employees for green cards, non-immigrant visas. I would recommend having a policy that explains when you will and will not do that, that you are not required to do it, and spells out your policies regarding who pays for what and when. And it also can help ensure compliance with the applicable laws and regulations, which can be very complicated. You have a separate I-9 compliance policy, a separate government investigation response protocol. That's the one that's really going to help you be prepared in the event of an ICE inspection. It would identify individuals within the organization who are responsible for immigration compliance, and it would determine who is to be called by the receptionist when ICE shows up at your door, which individuals are going to be responsible for gathering the documentation required by ICE. It would identify your outside immigration counsel who can be called to help review those documents before they're handed over to ICE. And it basically sets out a roadmap so that when the receptionist is greeted by an ICE agent, the receptionist isn't clueless about who to call and what to do, and doesn't, for instance, sign the part of that form that waives your 3-day right, your 3-day period before turning over the I-9s. There is an option to waive that and to hand the I-9s over immediately. You don't want to do that. Your compliance policy would also have program ensuring the compliance of your contractors and subcontractors, and would cover what you do in the event of receiving a no-match letter, and that tells you that an individual's social security number or name may not match the SSA's databases. If you get anonymous tips about workers and their employment authorization, if you get complaints about identity theft or misrepresentation, your policies need to cover these situations so that you are handling them consistently and thus can avoid complaints or avoid discrimination complaints if you're treating two different people differently in the same situation. I recommend that anyone in your organization that touches I-9s be trained to do so properly. You would need to document the fact that those people were trained and keep a copy of the training materials so that you can provide them to ICE and say, look, we're complying in good faith. The fact that these particular I-9s were not done properly was because of a rogue manager, for instance. And then the item that I mentioned on the previous page, an I-9 audit. This is where you really see a lot of savings. Now, you usually have to spend some money, whether it be in employee time to conduct the audit or in having an outside attorney or law firm or consultant perform the audit. But this means going through every single I-9 that you're required to have on file, finding out what the errors are, and going through the steps to correct those errors. I always recommend that even if you're going to do this yourself, you consult your immigration counsel first and have your counsel train the people who are going to be involved in the audit to ensure that they're making the corrections properly. I have seen companies go forward and, they had really good intentions, but by not really understanding what they were supposed to do, they made matters worse through their self-audit. Another option, at least going forward, and for some employers going backward, is to move to an electronic I-9 platform. A lot of great electronic I-9 software programs are out there that will ensure that the I-9s you're creating are compliant with the I-9 regulations. They won't let you leave things blank, for instance. And most of those systems are going to provide a seamless integration with E-Verify. So if you use E-Verify, you don't have to plug I-9 information in from a paper I-9 into the system. It prevents errors there and is a lot more convenient than having to plug that information into the government system. Another thing you can do to be prepared is to have a hotline that employees can call if they are concerned about some non-compliance somewhere, particularly with unauthorized workers or I-9s. Okay, so the most common fines that I have seen lately, these are ICE inspections within the past couple of years, seen ICE loving to fine employers for not signing the form, and that's the employee or the employer not signing or not dating the form, the failure of the employee to select the status in Section 1. And remember that despite the fact that Section 1 is for the employee to complete, it is the employer's responsibility to make sure that it's done. So the employee is obviously not going to be fined by ICE for not checking that box. You are. So it's your responsibility to look over Section 1 while the employee is still there, make sure they check the status box. Okay. I've seen a lot of employers accepting restricted Social Security cards. These are Social Security cards that say valid only with DHS authorization. The old one said valid only with INS authorization or not valid for employment. Those may be perfectly valid Social Security cards, but they are not acceptable as List C documents for the I-9. Amazingly, I continue to see employers simply failing to complete Section 2. So there's absolutely no proof on the form that the employer ever confirmed that the person was authorized to work. Failure to re-verify, so accepting temporary work authorization like an employment authorization card and failing to go back and re-verify that person's work authorization after the card expired. Timing errors are big, so if you did the forms late, those are considered substantive errors and you can be fined for that. And a huge one is backdating. It's really important that you don't try to make things look better by dating the forms earlier than you actually signed them. ICE catches on to that, usually because you may have used a version of the form that didn't exist before the date on which the person purportedly signed. If you're in the middle of an ICE investigation, they will sometimes use watermarks or certain document techniques to determine whether you are backdating forms. Okay, so avoid that entirely. That comes up as fraud and can get you into huge trouble. All right, how to avoid those fines for timeliness. This you can really only prevent going forward. You have to make sure all employees complete Section 1 of the form on or before the first day of work. You can only do this after you've offered them a job and they have accepted it. Okay? If they sign Section 1 of the form anytime after their first day of work for pay, the I-9 is late. Then you as the employer have a total of 4 days to complete Section 2. That includes the first day of work. We call it the Thursday rule. So you count day 1 of employment, and then you have 3 business days after that to complete Section 2. One really important thing here is a business day does not mean a day on which the employee works. It means a day on which the business is open. So if I start work on a Monday and my next day of work isn't until Thursday, but the business is open Tuesday and Wednesday, I still have to complete Section 2. I have to bring you my documents so you can complete Section 2 by the end of that Thursday, which is only my second day of work. Okay. The other thing here, you have to review original documents. Scans, faxes, copies, they're not enough. All right, and then the flip side of the timing rule, this is important because it means that once you don't have to keep an I-9 anymore, you can't be fined for it. And I'm going to recommend that you not keep them and definitely not hand them over to ICE. Even though you can't be fined for them, it doesn't mean ICE won't try to fine you for them, and then you have to pay a lawyer to get you out of it. And if there has been some sort of pattern or practice of something, those I-9s may be used as evidence against you even though you didn't have to have them and didn't have to turn them over. Okay? So the rule is you have to keep I-9s for all current employees who are hired on or after November 7th, 1986. Once someone is termed, then you do some math. You keep the I-9 for the longer of 3 years from the date of hire or 1 year from the date of termination. Again, this is only for people who no longer work for you. You do that math, figure out when you can get rid of the I-9, and as long as there's no litigation going on about that person or you're not in the middle of an ICE inspection, you can get rid of, and I mean shred, burn, get rid of that I-9, okay? All right. Okay. Some additional most common misconceptions and mistakes. Section 1 of the I-9 appeal box is not acceptable. It has to be a physical address. And I also recommend, unless the employee is living at the work site, don't use the work address there either. Don't allow the employee to use the work address. Social Security number in Section 1, it's only required if the employer uses E-Verify. If the employer does use E-Verify at the work site, then the employee must provide a Social Security number in Section 1. Otherwise, if the employee does not list one, you should not require that they add it. The employee has to select a status box in Section 1, and that status has to be consistent with the documents presented. Again, timing, Section 1 has to be signed and dated on or before the first day of work. Preparer translator certification section should only be used if a preparer or translator actually helped the employee and if the employee actually needed assistance to complete the form. And the Spanish version of the I-9 form, as helpful as it is, you're only allowed to complete that and use it as your I-9 in Puerto Rico. Okay. Here's a sample of Section 1 properly completed. Again, make sure the status box is selected. The date of birth, I see more errors here than I ever would have believed. Employees are filling out a lot of paperwork on their first day of work. Sometimes they put the current year, sometimes they put the current date. Just look at it, make sure that it's conceivably the person's date of birth, and then compare it against the documents they present. A Social Security number, as I mentioned, is optional if the employer does not use E-Verify, and timing is key. All right, Section 2 tips. You have to complete Section 2. Even if you make copies of documents and keep them with the I-9, that doesn't get you out of the requirement to actually fill out the information in Section 2 of the form. Be careful not to over-document because that gives rise to evidence of discrimination. And by over-documenting, I mean if an employee dumps out her purse in front of you and says, here's everything I have, take what you need, you can't take the driver's license and Social Security card and U.S. passport and birth certificate and record all that information on the I-9. You instead need to turn it back to the employee, say, you know, here's a list of acceptable documents. I need you to choose either one List A document or two documents, one from List B and one from List C, and provide me with those selected documents. Okay. You have to fill out the data PIRE. Here the government seems to have been sort of playing tricks on you. It's a really small box in the middle of a lot of tiny text, but you have to complete that date. You have to review original documents, and we've talked about timing here, so I'm not going to focus on that. The other thing that it's not really a recent change anymore, but as of April 3rd, 2009, you can no longer accept an expired document for the I-9. If it has an expiration date, it has to be unexpired at the time presented. And that mainly is going to affect List B documents and the U.S. passport. And here again, it's like Section 1, we have a sample, Section 2. Social Security card, I recommend that you actually write the word card. Otherwise, I have seen ICE agents say, well, what's a Social Security? That's not a document. It's rare, but it happens, and you want to avoid any kind of conversation like that with the government. And then actually list SSA, DHHS, or Department of Health, Education, and Welfare for the issuing authority. Just SS is not enough, and a Social Security number is also not a document. Okay, List B, again, these have to be unexpired at the time presented. The data PIRE, as I mentioned, has to be filled out. The date of signature, this is how the government knows you did this on time, so make sure you know what day it is when you're signing the form. And just like in Section 1, the employer address does have to be a physical address. A P.O. box is not enough. Okay. Again, I can't stress it enough, you have to review original documents. Photocopies are not acceptable. The only exception is you can review an original certified copy of a birth certificate. Okay, your role is not to be a document expert, but you have to make sure the documents presented reasonably relate to the individual and appear to be genuine. Okay, so you're looking for obvious signs that the document is fake. I've seen people paste their photographs on. I've seen people erase things and write it in or type it in with a typewriter over where the old information was. You know, you see documents more often than I do, originals, and you have to sort of rely on your gut instinct and know, you know, wait, this document just isn't right. Okay? Again, avoid document abuse. A green card holder does not have to show you his green card. And the other way to easily spot a fraudulent document is to look for misspellings. The government makes mistakes, but they usually don't misspell the agency name. I've seen some green cards that were purportedly issued by the Department of Homeland Security. Okay. All right. We have gone over this, but here it is in writing for you. I'm going to move right along. Some questions I get frequently about Social Security cards is, you know, what do I do if it's not signed? You have to accept it, even if it's unsigned. Even if it says not valid if signed, if unsigned, not valid until signed, you have to accept it. Same thing with a U.S. passport. I know it says valid only after being signed by the bearer or something like that. For I-9 purposes, it doesn't matter whether it's signed. Okay? If a Social Security card is laminated and it says on it not valid if laminated, then you cannot accept it for I-9 purposes. Metal or plastic reproductions of Social Security cards are not Social Security cards, and you cannot accept them for I-9 purposes. And the dates that you'll see on the bottom of a Social Security card, those have been issued with dates for the past several years. Those are not expiration dates. Those are typically issue dates. So don't list that as an expiration date on the I-9. All right. Document number for a green card. You can see I've got it circled. It's a 13-digit code, and I'm not kidding. It starts with 3 letters. It's followed by 10 numbers. That's the document number you need to be recording for green cards, not the A number. Right? And then this is a newer version of the green card, started being issued. It's been over 2 years now. I was really excited. Again, I mentioned I was a nerd about this kind of stuff. I was excited when they came out with this card because I was like, awesome, it's going to be green, and we've been talking about this green card for so long. This one's actually green. Awesome. It is green, and I thought surely they'll take this opportunity to make it easier for employers to know where the document number is, and instead they've made it more difficult. You can see here on the front is the USCIS number. That's the A number. The document number itself only appears on the back of the form. And you can see it there in the hologram. It says card number and then A number, and then in the code, just like on the old version of the card, you can see the number there as well. Okay. What if you use E-Verify? E-Verify changes the I-9 process a little bit. Even if your policy is not to keep copies of supporting documents, if you're an E-Verify user, you do have to keep copies now of green cards, U.S. passports, and EAD cards that are presented for I-9 purposes. You have to require the Social Security number in Section 1. You can only accept a list B document that contains a photo. And for some employers, it changes timing a little bit. To the extent that you used to do I-9s last minute, you might want to try to get them done a little earlier because the E-Verify deadline is the same as the I-9 deadline. All right, and as I mentioned before, it adds a layer of enforcement because there are additional opportunities for employers to discriminate and as such, additional opportunities for the government to sue you. And we've recently seen, they aren't necessarily enforcement actions, but the Department of Homeland Security has been performing desk audits on E-Verify users where they see a pattern of potential misuse. You want to avoid being the subject of one of those because it's pretty in-depth and requires a lot of time to respond to. This is just a little bit about what I do, what we have here at Cypress Shaw, which is the Immigration Compliance Center. We provide a lot of services relating to the issues we've been talking about today. I don't want to focus on it. I just want you to know that to the extent that you don't already have great immigration counsel out there, and I'm sure most of you do, but if you don't and you need to talk to someone about I-9, E-Verify, and immigration compliance issues, we are here for you, and my contact information is there on your screen. Now we're going to move to questions and answers, and I think we have time for quite a few. Meredith?
Yep. Bear with me just one second, everyone. I'm just going to grab the questions box here and manipulate it so I can read all your questions. And if we don't get to your question today, Nikki has her information up there as well. You can also email me at info@edgeinformation.com. And we'll get back to you on any that we don't get to today. All right. Let's see. First question. I am wondering what you can tell us about the new I-9 that is rumored to be coming in August.
Yeah, there's a new Form I-9 that was proposed a couple months ago. It is a longer form, so this simple one-page form we've been talking about for so long is going to become a two-page form. And that, despite the fact that we aren't through the comment period is over, people have submitted comments about the proposed form, and we expect some sort of final decision about what the final form will look like. But the word from the government is that it is going to be 2 pages long. It adds some places for information like the employee's email address, for visa-related information for foreign nationals, and it provides some additional space in Section 2, particularly where you have to accept more than just the 2 documents. So if you work a lot with foreign nationals, foreign students will have to present sometimes 3 documents for List A, and it provides additional space for that. There are great things about the form. There are some not so great things about the form. If you're interested in it, you can contact me and I'll send you a copy of the sample form along with a comment that I worked on with several other attorneys about our thoughts. And it's a long comment, so it's a lot of thoughts about that new proposed form. I'm not sure whether it's actually going to come out in August. I know the current form has an expiration date on it. It's often the government will just ask employers to continue to use the existing form until the new one comes out, because there's no certainty about whether that's actually going to come out next month.
Okay, great. Next question. Can ICE request I-9 forms on terminated employees, i.e. seasonal employees?
Yes, as long as the I-9 is within the retention requirement, so the person is still a current employee or was termed, and their I-9, their date of hire was less than 3 years ago and their term date was less than 1 year ago, ICE can still request that form.
Okay. What if I have located an I-9 form from 2009 that is incomplete and the employee is still working here?
I would ask you to talk with your immigration counsel about the specifics of that situation. In general, if you don't have an I-9 for someone or it's incomplete, my recommendation is usually to try to do everything you can to get that I-9 completed now. It's better to have a late I-9 than no I-9 or an incomplete I-9. And there is a statute of limitations for I-9 errors. Once corrected, ICE has 5 years to file a complaint against you in order to fine you for those errors. So if you correct them, the sooner you correct them, the better, because you start that statute of limitations period to toll.
Okay. Next question is, I have multiple work site locations. Each maintains their own personnel files. Is there anything that says I-9 must be kept on site, or can they be maintained at the corporate office?
There's no requirement about where specifically I-9s be maintained. They can be maintained locally or centralized. It's generally recommended that they not be kept in the personnel files, that they do be kept separately, and there are a couple reasons for that. One is to avoid discrimination charges, and another is just to make it easier to gather those forms in the event of an ICE inspection. Some employers like to centralize them, to have a little more control, and audit I-9s as they come in. Other employers like to keep them on site so that if ICE shows up, the I-9s are already there at the location.
Okay. Next question is, we have just become an E-Verify employer. Prior to this, we requested new employees to bring Social Security cards, driver's licenses, and birth certificates for personnel file. Can we still do this since it is for record only, not completion of the I-9 form?
If you have a legitimate reason to request a document, you can still request it, as long as it's clear that it's not being requested for I-9 purposes. So for instance, a lot of companies employ people, and those people's jobs are to drive company vehicles. Those employers legitimately request copies of, or originals, they make copies of driver's licenses. It's perfectly fine to do that. Just make it clear that you're requesting that specific document for a specific purpose, and that purpose is not the I-9.
Okay. Next question is, what should an employer do if the I-9 of the current employee cannot be located?
Again, I would talk to your counsel, but generally if you don't have an I-9 on file and you can't find it and it's a current employee who was hired on or after November 7th, 1986, I recommend generally, again, going forward to complete the I-9 now. Again, an I-9 that was completed late is usually better than no I-9 at all.
Okay. Next question is, someone changes their name and fills out a new I-9 form. Should the old one be shredded?
No, absolutely not. You aren't required to do anything to an I-9 when an employee's name changes. You can update the I-9 form due to a name change. Typically, it's not a good idea to do an entirely new I-9 when someone's name changes, because you could be charged, again, with document abuse or discrimination by requiring the person to bring documents again, even though they brought them before. You may require, as a business practice, that someone bring in proof of their name change in order to change their name in your records. But for I-9 purposes, the only thing you need to do, if anything, is update their name in Section 3 and sign. You don't require documentation at all.
Okay, great. Next question. If an I-9 form arrives to the corporate office incomplete, can the HR corporate staff complete and or make corrections to the form, i.e. missing DOH or missing ER address?
That depends on the circumstances, and I'm going to recommend that you talk to your immigration counsel on that one. I'm sorry to keep doing that, but there are certain things in Section 2 that any employer representative can complete, including, for instance, the employer name and address. Anyone can fix that. There are certain items that may only be corrected by certain people.
Okay, thanks. Let's see. There's a couple of questions that are along the same lines, so I'm trying to look here and get some new ones. There's a lot of questions about maybe getting a copy of the slides or the presentation. I am recording this, so I will be getting a link to those of you that are asking for a copy of the presentation so that you can watch this webinar at a later date. So just email me, or I have your questions all here, so I'll have them for later to send you the slides or the recorded webinar. But again, you can email me at info@edgeinformation.com if you have a need for the slides or the recorded presentation. Let's see. Next, we'll do a couple more questions. Nikki, is that good? And then we'll...
Yeah, that's fine.
Okay. Let's see. Our associate files are now all electronically held on our in-house database. We have uploaded the original I-9s to the electronic database. Do we need to store the original paper copies, or is the electronic copy sufficient enough?
There are very specific and complex regulations surrounding electronic storage of I-9s. And so until you've had your electronic storage system evaluated and to ensure that it complies with the I-9 regulations, I'm going to recommend keeping the originals because it's possible that ICE would take the position that your non-compliant scanned copies are not I-9s at all.
Okay. Let's see. Is the I-9 valid if the employee signs above the space provided in error?
Yes, as long as the signature, it's clear that the signature relates to the certification language that the person's being asked to sign, that attestation language, it's fine. It doesn't matter if it's in the particular box or not.
Okay. All right, let me just go through these. I think that's pretty good for covering topics that we haven't had yet for questions. So let's see here, a couple more. Getting a lot of requests for the slides, so that's good. Okay, we just had one come in. What can a company do to ensure that they are not accused of requesting specific documents as proof of eligibility, i.e. just provided the DL and SSC?
Yeah. What I usually talk to my clients about is, again, policies and practices. So you make it clear in your policies that each employee is to be provided the list of acceptable documents and be given an opportunity to present List A or List B and C documents. You can even come up with a script for people to follow when they are completing I-9s so that you can show the government, look, this is how we do it every single time. We have a script we require our HR folks or managers to follow so that they do not request specific documents.
Okay.
There are things you can do, policies and scripts.
Okay, great. Are 1099 employees required to fill out an I-9?
The only time someone completes an I-9 is if they are performing services in the U.S. in exchange for wages or other payment. If they're an independent contractor, and there are a lot of legal rules about who's an independent contractor and who's an employee. If they're an independent contractor, you do not need to have an I-9 on file. But I would say you can't get around the basic purpose of the I-9, and you should not allow independent contractors to work for you if you know that they're not authorized to work.
Okay, great. All right, Nikki, we had a lot of good questions, so I'm just going to go ahead and end the question segment now. And for all of you out there, I do have your requests for the slides, and if we didn't get to your question, I'll make sure that we do get to them later on today or this week. I want to thank you all again for taking time out of your day to join us. And Nikki, of course, thank you very much for the presentation. It was very educational and informative.
Thanks for having me. It was fun.
Great. All right, well, thanks, everyone, and we'll be in touch. Bye-bye.